Okay, so we will start with lesson 20 today and we'll try to complete it today itself. Right.
Okay.
Okay, so lesson 20, it deals with another act. It is Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act. It is also called as the POSH Act. Okay, so we'll be dealing with POSH Act in this particular lesson. Why do you have this act? Why do you need this? It is an act for providing protection against sexual harassment of women at workplace and for the prevention and redressal of complaints of sexual harassment or matters connected therewith or incidental thereto. So we'll see why and how this act came to be. We are starting with the history of the legislation. Sexual harassment of a woman in a workplace is a serious concern to humanity on the whole. It cannot be construed in a narrow sense that it is only when a person, directly or physically, abuses a person, you can call it as a sexual harassment. It may also include sexual advances and other verbal or physical harassment of a sexual nature. The victims of sexual harassment may face psychological and health effects like stress, depression, anxiety, shame, guilt, and so on. So it is a violation of fundamental rights of a woman because women also have the right to equality under Article 14 and 15 of the Constitution. They also have the right to life with dignity under Article 21 of the Constitution. And like any other human being, they have the right to practice any profession, to carry on any occupation, trade, or business, which includes the right to a safe environment free from sexual harassment. So, as it is a right which is conferred to women by the Constitution, there needed to be a legislation guarding these rights. So that is why this act came into place. The principle of gender equality is enshrined in the Constitution, in the preamble, in the fundamental rights, in the fundamental duties, and in the directive principles. But we didn't have any act for it for a very long time. However, workplace sexual harassment in India was for the very first time recognized by Supreme Court of India in the landmark judgment of Vishaka versus State of Rajasthan only in the year 1997. Till 1997, sexual harassment was not recognized as a violation of fundamental rights, nor was it recognized as any sort of crime. So we didn't have a law, guarding the rules of women against sexual harassment. So only in 1997, with the landmark judgment, is called as a Vishaka judgment, there came a change in India. Okay, for the first time ever, Supreme Court acknowledged that we needed to have a law for combating workplace sexual harassment. It found out that it finally, acknowledged that sexual harassment is a big issue. So the judgment which came is called as the Vishaka judgment, very famous. And based on the judgment, Supreme Court brought out certain rules and guidelines that all the workplaces should follow. So it is called as Vishaka guidelines, as there was no particular act to follow in terms of sexual harassment. Based on this judgment, Supreme Court laid down certain guidelines, and those guidelines are called as Vishaka guidelines. It provided a mechanism to redress grievances pertaining to workplace sexual harassment. So we'll see what the case was all about. In 1992, a woman, she was employed with the Rural Development Program of the government of Rajasthan, and she was working against child marriages. She was protesting against child marriages, but she was brutally gang raped on the account of her efforts to stop the practice of child marriage. So, this incident revealed the hazardous nature of working women exposed to on a day to day basis and highlighted the urgency for safeguards to be implemented in this regard. So, championing the cause of working women in the country, the women died out. Okay, and to bring justice to her, women's right activists and lawyers, they filed a pill, that is your public interest litigation, in the Supreme Court of India. And you know that you cannot name the victim, so they used the name Vishaka. Under the banner of Vishaka, they filed a case in the Supreme Court. The Supreme Court of India, for the first time, acknowledged the glaring legislative inadequacy and acknowledged workplace and sexual harassment as a human rights violation. It was only in 1997, after this case was brought into light, Supreme Court finally, accepted that sexual harassment is prevalent. There is no laws regarding it, and it is a human rights violation. And in framing the Vishaka Guidelines, Supreme Court of India placed reliance on the Convention of Elimination of All Forms of Discrimination Against Women, which was adopted by the General Assembly of UN in 1979, to which India has both signed and ratified the same. So, based on that convention, it has formed the Vishaka Guidelines. Are you guys there?
Yes, ma'am.
Right.
Yes. Who is this baby Shalini? Yes.
I am also a student, ma'am.
Your name?
Baby Shalini.
Okay. Welcome. As I haven't seen you for the past, 5 to 6 classes, I didn't
Yes.
know. I only thought where there were three students. Okay, so we'll continue. All right, so we'll see what was the judgment, what was the Vishaka guidelines all about. As per the Vishaka judgment, the Vishaka guidelines was issued under Article 32 of the Constitution until such time a separate act was enacted for the same. Okay, so it would have the effect of law and it have to be mandatorily followed by organizations, whether it is in the private or the government sector. So there was no act which was, regarding protection of women. So what they did, instead of the act, till the time the act is formed, they issued some guidelines. And until the act is drawn up and enacted, these guidelines will be having the effect of law, which means all of them should compulsorily follow them, whether the organizations are from the private or government sector. So first, they defined what is sexual harassment in the judgment. Sexual harassment includes such unwelcome sexually determined behavior, whether it is done directly or by implication or by conduct, as physical contact and advances, a demand or request for sexual favors, sexually colored remarks showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of sexual nature. Okay. Where any of these acts are committed in circumstances under which the victim of such conduct has a reasonable apprehension that in relation to the victim's employment or work, such conduct can be humiliating and may constitute a health and a safety problem. And it amounts to sexual harassment in the workplace. It is discriminatory, for instance, when the woman has reasonable grounds to believe that her objection would disadvantage her in connection with her employment or work, or it may create a hostile working environment. So, why is this a very serious issue? Is that a woman going out like everybody else, she's doing her job, and when she faces sexual harassment, the thing is that it is usually of two types. One, they may openly state that if you don't do this, if you don't do this for me, or if you complain about this, then you will not go ahead in your job. That is, you'll not get promotions, you'll not get, bonus, something like that. That is going to be a detriment to her employment or work. Or if she objects, if she says no, then it may create a hostile working environment where she'll be put down or where she'll be pointed out and, bullied for saying no. So this is going to be a big problem for the women to continue working in that particular hostile working environment. That is why it is called as sexual harassment in the workplace, and it is a very serious issue which has to be dealt with. The Vishaka judgment initiated a nationwide discourse on workplace sexual harassment, and it threw out wide open an issue which was swept under the carpet for the longest time. So the first case after Vishaka guidelines were put in place was Apparel Export Promotion Council versus. 'A. K. Chopra. Okay, so in this what happened is, this person, Superior Office of Delhi-based Apparel Export Promotion Council, was found guilty of sexually harassing a subordinate female employee at the workplace. Okay, so because of his actions, he was dismissed. Okay, he was fired from his job, and he went to the court to appeal against this dismissal. Okay, so Supreme Court it upheld the decision. They said that it is completely okay to dismiss the person, and it also enlarged the definition of sexual harassment by ruling that physical contact was not at all essential for it to amount to an act of sexual harassment. Okay, Supreme Court explained that sexual harassment is a form of sex discrimination projected through unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct with sexual overtones, whether it is done directly or by implication, particularly when submission to or rejection of such conduct by the female employee was capable of being used for affecting her employment and unreasonably interfering with her work performance and had the effect of creating an intimidating or hostile work environment for her. So the consequences are the same. So if she doesn't say okay, or if she kind of rejects the actions which is put on her, then it may adversely affect her employment, that is her working opportunities. She may even be dismissed, or she may not be promoted. Something like that may happen which will affect her work. Which will affect her work, it will automatically affect her life, whether it is financial or physical. Then it will also create a hostile work environment, that her workplace will not be safe for her to work anymore. So, in light of the above judgment, the very first efforts toward implementing a law for protection of women from sexual harassment was taken in 2007. A bill called Protection of Women Against Sexual Harassment at Workplace was introduced in the parliament. But unfortunately, this bill it did not translate into an act. Okay, on 7th December 2010, the Protection of Women Against Sexual Harassment at Workplace Bill 2010 was introduced in the Lok Sabha, and Lok Sabha, as usual, it discussed and it transferred and referred it to a Parliamentary Standing Committee on Human Resource Development led by Sri Oscar Fernandez. And on December 30, 2010, by examination, the Standing Committee came out with its report in December 2011. So 2010, the bill was proposed. 2011, recommendations were given by the Standing Committee. Based on the recommendations, subsequent changes were made to the original bill and including the title of the bill, which means the title was changed. It was the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Bill 2013. So this was a changed name. Okay, so the change of the title clearly reflects that the ministry wants not only to focus on redressal of complaints of sexual harassment, but also focus on preventing and prohibiting sexual harassment. So that is very important. Not only deal with the problem after it occurs, to stop the problem from happening itself. So as already said above, from 2007 till 2013, several bills related to prevention of sexual harassment were passed, one after the other, but they were all remaining, pending in the House of the Parliament, either the Lok Sabha or the Rajya Sabha. So based on this, Ms. Medha Kotwal Lele, a coordinator of Alochana, a center which works on the documentation and research on women, they filed a petition in the Supreme Court highlighting that there is increase in the number of sexual harassment cases, and she argued that the Vishaka guidelines were not effectively implemented. Okay, so in that case, the court gave the ruling that Vishaka guidelines have to be implemented in form, substance, and spirit in order to bring in gender parity, so that women can work with dignity, decency, and due respect. Okay. Then you have the protection against sexual harassment and the right to work with dignity are universally recognized human rights by international conventions and instruments, such as the Convention on the Elimination of All Forms of Discrimination Against Women, which had been ratified on 25th June 1993 by the Government of India. So it was expedient, which means it was high time. It was necessary to make provisions for giving effect to said convention for protecting the rights of women against sexual harassment at workplace. So then came your first legislation specifically addressing the issue of sexual harassment at workplace, the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. It is also abbreviated It's called as the POSH Act. Okay, it was enacted by the Ministry of Women and Child Development of India in 2013, 16 years after the Supreme Court judgment in the Vishaka case. 16 years after the Vishaka judgment and Vishaka guidelines, we had the first act against workplace sexual harassment in 2013. Okay. So, government also subsequently notified rules under the POSH Act titled the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Rules 2013. You can call it as the POSH rules. And one more important thing is your Criminal Law Amendment Act. It included sexual harassment, stalking, and voyeurism as criminalized offenses in 2013. Okay, so what is the objective of the act? The objective is very clear to prevent and protect women against workplace sexual harassment, and if it happens, to ensure effective redressal of complaints of sexual harassment. The preamble of the act reads that you should give the woman right of equality under Article 14 and 15 of the Constitution, and she should also have the right to live her life with dignity under Article 21. Okay, and to also uphold the provisions to give effect to the Convention on Elimination of All Forms of Discrimination Against Women, which was ratified by India on 25th June 1993. So this is what is there in the preamble of the Act. What is workplace sexual harassment? It is sexual, unwelcome, and the experience is subjective. Very, very important. You cannot say sexual harassment na இப்படி பண்ணாதான் இப்படிதான். What one person feels like sexual harassment may not be the same for other person. So it may not affect the persons equally in the same manner. It is the impact and not the intent that matters, and it is always occurring in a matrix of power. Usually, you can see that the people with power or responsibility or authority, they subject women under them, no, they subject female subordinates working under them to sexual harassment. Workplace sexual harassment not only creates an insecure and hostile working environment for women, but it also impedes their ability to deliver in today's competing world. Apart from interfering with their performance at work, it also adversely affects their social and economic growth, puts them through physical and emotional suffering. So, as I already spoke to you briefly, there are two types or two forms of workplace sexual harassment. It is the common MO. MO is modus operandi, the method of operating. So, the common MO of inappropriate behavior is quid pro quo. That is something in return. This for that. If you do this, I will give you a promotion. Right? If you do some sexual favor, I will give you a promotion. Or if you don't do this, you threaten them about their employment status, like you'll be removed from the job, you'll be demoted, you'll not be promoted, something like that. So that is quid pro quo. That is the first type. Then hostile working environment, creating a hostile, intimidating, or offensive working environment, humiliating treatment likely to affect the health and safety of the female employee. So this is the two forms of workplace sexual harassment. Then you have applicability. This act will apply to organized as well as unorganized sector. So you can see unorganized sector is self-employed or having less than 10 workers in India. So it applies to government bodies, private, public sector organizations, NGOs, organizations carrying out commercial, vocational, educational, entertainment, industrial, financial activities, hospitals, nursing homes, educational institutes, sports institutions, and stadiums used for training individuals. It also applies to a dwelling place or a house. Okay, so it also includes if you have a maid at home. Even she is covered under this act. This act applies to homes also. Then you have the important definitions covered in section 2. The first definition is the aggrieved woman. Who is the aggrieved woman? Aggrieved woman means in relation to a workplace, a woman of any age, whether she is employed or not, who alleges to have been subjected to any sexual harassment by the respondent. And if it is in relation to a dwelling place or a house, woman of any age who is employed in such a dwelling place or a house. You can see if it is in workplace, women may be employed, may not be employed also. But if it is in a dwelling place or like a house, the women should be employed in that particular house. Clear? So the motive of the act is to provide a safe and secure workplace environment to all women, irrespective of their work status. So the right of women working or visiting any workplace also is covered in the definition. right? The act also covers a woman who is working in a dwelling place or a house. Then you have the definition of the term appropriate government. In relation to a workplace which is established, owned, controlled, or wholly or substantially financed by funds provided directly or indirectly by central government, then the appropriate government is central government. If it is an establishment in relation to state government, then you refer to state government. In relation to any workplace which is not covered under the first point, that is clause 1, then falling within this territory, the state government, that is for the private sector, appropriate government is the concerned state government. So if it is related to central government, the establishment, central government is the appropriate government. If it is related to state government is the appropriate government. Other than this, if it is a private establishment, then where the private establishment is situated in, that state government will be the appropriate government. Clear?
Yes, ma'am.
Okay, just give me a minute. I'll be back. Yes, sorry for the inconvenience. We'll move on. Next definition is domestic worker. Domestic worker means a woman who is employed to do household work in any household for remuneration, whether remuneration is in form of cash or kind, either directly or through any agency, whether she is a temporary, part-time or a full-time worker, it doesn't matter. But the domestic worker will not include any member of the family of the employer. Then you come to the definition of the term employee. A A person employed at a workplace for any regular, temporary, or ad hoc or daily wage basis, either directly or through an agent, including a contractor with or without the knowledge of the principal, whether it is for remuneration or not, whether they're working on voluntary basis or not, they are considered to be employees. It includes a co-worker, a contract worker, a probationer, a trainee, an apprentice, or you can call them by any other name. They are considered to be employees. So they're covered under this act. Then you have who's an employer. So it refers to any establishment which is related to the government or local authority or any branch of such government establishments. It can be any workplace if not covered under subclause, any person responsible for the management and supervision of the workplace, and a person discharging contractual obligations in respect to his or her employees. If it is in relation to a dwelling place or house, a person or a household which employs the benefit of employment of a domestic worker. And the next definition is respondent, the person on whom the accusation is made. The person against whom the agreement has made a complaint again under Section 9 is called as the respondent. Then you have definition for sexual harassment. Again, it is in line with what Supreme Court gave us a definition in the Vishaka judgment, the same thing. Okay, so it includes any one or more of the following unwelcome acts of behavior, whether directly or by implication, namely physical contact and advances, a demand or request for sexual favors, making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, or non-verbal conduct of a sexual nature. Okay, the key distinguishing feature of whether something is a form of harassment or not is the conduct is unwanted and unwelcome by the recipient. So it creates a intimidating, offensive, or hostile working environment. They've given us an example of sexual harassment. An example would be a working environment where an individual is subject to unwelcome comments about her body type, resulting in a women employee feeling embarrassed and unable to work properly. This is also a example of sexual harassment. The Act has defined what constitutes sexual harassment under Section 2, Clause N, and under Section 3, it has further widened the definition of sexual harassment by providing that any of the following circumstances may also amount to sexual harassment. Number one, implied or explicit promise of preferential treatment in the victim's employment. That is, if you do some sexual favor for me, I will, help you better your, living standards or get better in your employment or something like that. Implicit or implied or explicit threat of detrimental treatment in the victim's employment. If you say no, then threatening them with their job. Implied or explicit threat about the victim's present or future employment. Again, if they say no, then threatening to take away their employment, present or their future potential. Interferes with the victim's work or creating an intimidating or offensive or hostile work environment for her, humiliating treatment likely to affect the victim's health or safety. All these will amount to sexual harassment under this act. It is defined in Section 3. Apart from your definition in Section 2, Clause N, Section 3 also brings in these circumstances which may amount to sexual harassment. So definition is very wide. It provides for direct or implied sexual conduct, which may mean that what is implied sexual behavior for one person may not be the same for another person. Okay, so the definition also provides that harassment may be verbal or a non-verbal conduct. A mere statement in a case where the plaintiff requested defendant number one to instruct the attendants to switch off the AC. So the women requested the attendants to switch off the AC, but in reply, uh, the defendant number one said, "Come close to me, you will start feeling hot." So it is a statement made. It is an implied sexual harassment. Okay, so it can be called a sexual harassment under this act. Then you have the definition for workplace. You can just go through it later. It involves everything. Okay, not one thing is left out. And for that, why do you involve everything? What is the need is what is explained below. A logical meaning should be given to the expression workplace so that the purpose for which the guidelines have been framed is not made unworkable. So if you keep a strict meaning to what is a workplace, it is only an official setting or only in an office, only in a factory. If you keep that very strictly restricted, then this act will not work. Okay, so the definition of the word workplace should be kept flexible enough to, make this act work. For that, we have an important case law. In the case of Saurabh Kumar Malik versus Comptroller and Auditor General of India, the problem was that this fellow, the Saurabh Kumar Malik, he sexually harassed this senior woman officer. Okay, but this harassment, it took place in the official mess where the woman was residing, where the officer was residing. It did not happen in the office per se. It happened in the mess, office official mess where the senior officer, women officer, was staying. Okay, so the point which is kept by this person, the accused, is that he said it cannot amount to workplace sexual harassment because it did not occur in the office. It occurred in a place where the woman was residing. So that is what his point was about. He said, I didn't do it in the office, so it cannot be workplace sexual harassment. And one more thing he said was, it was with a senior officer. So what would be the benefit, or how can I blackmail her, or how can I ill treat her, something like that he asked. So this was the 2 points he made to the court, Delhi court. So Delhi court again observed that it may not be a person necessarily subordinate to the abuser. It can be anybody. Okay, so that we have to take into point. And it said that the act cannot be seen in a narrow or pedantic approach. It cannot be taken. So when I say workplace, I don't strictly refer to office. It also refers to your official mess also, because we are living in times where we are working from home. You can take the example of this class itself. You are at your homes in different cities. I'm in a different city, but still we are able to meet and we are taking classes. Is this an official setup? Yes. Similarly, work also, you know that work from home is becoming more and more popular. So in the era of technology and internet, you cannot say that only this is a workplace, only office is a workplace. No, that strict definition cannot apply. Okay, so for example, a person can work from his house also. And if he harasses his secretary or his PA at his house, can he claim that I didn't do it in the office, that therefore it is not a sexual harassment? No, you cannot say that. You cannot get away with saying that. Therefore, the definition of the word term workplace includes proximity from the place of work. If the place அவங்க எந்த இடத்துல abuse நடந்துச்சோ, if the place is under the control of the management, whether it is a residence where the working woman is residing, such a residence has to be an extension or a contiguous part of the working place. So in conclusion, Delhi High Court held that official mess where the employee was alleged to have been harassed definitely falls under the term workplace. Clear, all of you?
Clear, ma'am.
Yes. Then you have the definition of the term unorganized sector. Okay, number of workers is less than 10, or there are individuals who are self-employed and such, then it is called as unorganized sector. So these are the definitions that you need to keep in mind. Moving on, we come to the important part of your act. The act has provided for the setting up of two types of complaint mechanisms. One is ICC, not your International Cricket Council. It is Internal Complaints Committee, and then you have Local Complaints Committee. Two complaint mechanisms: Internal Complaints Committee (ICC), Local Complaints Committee (LCC). So, what is the Internal Complaints Committee? Who has to set it up? According to Section 4 of the Act, it requires every employer to set up internal complaints committee at each office or branch or organization employing 10 or more employees. Okay, so if you are going to be working in an office in the future, if there are more than 10 employees, 10 or more employees, then there must be a internal complaints committee in your establishment. What is the purpose? To hear and redress grievances pertaining to sexual harassment. So this is mandatory as per Section 4. It is compulsory for all the employers to have a ICC, Internal Complaints Committee. So every employer of workplace shall order in writing constitute a committee to be known as the Internal Complaints Committee. Okay, if your office has different branches, then each branch will have a separate internal complaint committee. Who will be the members? There will be a person called as the presiding officer. All these people will be nominated by the employer. Okay, so your boss, the company's owner, or the MD or CEO, someone like that. So there will be a person called as a presiding officer. The presiding officer shall be a woman employed at a senior level. Okay, if in the particular office there is no senior level women employee, then from other branches you can take a officer, senior level women officer to be the presiding officer. Right, and then members. There should be not less than 2 members from amongst the employees, preferably committed to the cause of women, and they should have had experience in social work or have some legal knowledge. Then you can also engage an external member, that is apart from the employee, someone from outside, from an NGO or association who are committed with the cause of women and they have dealt with issues relating to sexual harassment. And one half of the members should be women in the ICC. Okay, this is in regards to the composition of ICC. We'll stop with this. We'll continue in the new meeting.